Imagine buying a piece of property specifically so you can live right next to your airplane. Sounds like the absolute dream, right? Well, what if your neighbors suddenly voted to kick you out? Welcome, everyone. Today we're unpacking a real-life, 13-page administrative law judge decision from the Arizona Department of Real Estate. It's the case of Magnus McLeod versus Mogollon Airpark Incorporated. And let me tell you, this isn't just some dry legal document. It's a gripping, highly relatable story about what happens when the romantic dream of living with your airplane collides head-on with the everyday reality of HOA bureaucracy. If you have ever dealt with a neighborhood association, you're definitely going to feel the tension in this explainer. All right, here's our flight plan for today. We'll start with a welcome to Mogollon Airpark, look at the dueling legal petitions, break down the math behind the rules, examine living space and phone towers, reveal the judge's final verdict, and then finally cover the 2023 rehearing rejection. Section 1. Welcome to Mogollon Airpark. We're starting out at a totally idyllic flying community where one homeowner's dream hit a massive bureaucratic wall. Before we get into the actual conflict, let's just make sure we're on the same page with a couple of quick terms. First, a tract hangar is a specific plot in this community meant primarily for aircraft storage. Second, we have CCRs, which are your conditions, covenants, and restrictions. You know, the legally binding rules that govern what you can and literally cannot do in a planned neighborhood. Understanding this sets the stage, because when someone buys property here, they are legally bound by those CCRs. But the real friction, and honestly why this matters to anyone living in a planned community, happens when neighbors decide to change the rules of the game. So let's look at how fast things escalated. In February 2017, Magnus McLeod buys the Tract G hangar from his brother. According to the administrative record, he fully expected to live there. He makes interior living improvements, moves in, the whole shebang. But the honeymoon doesn't last. By October 2018, the HOA passes an amendment to the CCRs that strictly limits hangar living. Then, just 2 months later in December, the HOA hits MacLeod with a first notice of noncompliance and a $100 fine. And get this, it was driven by a complaint letter signed by over 25 of his own neighbors. Just imagine that level of neighborhood tension. Fast forward to June 2020, and everyone is sitting in a formal administrative hearing. Section 2, the dueling legal petitions. At this point, both sides decide to go on the offensive, turning the whole dispute into a high-stakes legal boxing match. It became a total standoff. MacLeod filed Petition 19, claiming that the HOA's October 2018 amendment was completely invalid. His argument? Under state property law, you just can't change the rules without unanimous consent from all the owners. Fighting right back, the HOA filed Petition 34. Their stance was that the amendment was perfectly valid, totally legally adopted, and that MacLeod was actively violating it by using an aircraft storage hangar as his full-time permanent home. They basically wanted an injunction to force him out. Section 3, the math behind the rules. The entire crux of this legal battle actually comes down to a math problem about Arizona's state statutes and community voting. The HOA's entire defense rested on one specific threshold, 75%. They argued that according to their original governing declaration, they didn't actually need everyone to agree to change the neighborhood rules. They only needed an affirmative vote or written consent from 3/4, so 75%, of the lots in the subdivision. And, well, they managed to secure at least that many signatures to pass the new restrictions. MacLeod, however, counted with a very different number, 100%. He pointed straight to an Arizona state law, ARS Section 33-1817. He argued that because this new amendment applied to fewer than all of the lots, like, for example, it didn't apply to Tract B, which was a common area, state law actually demanded a 100% unanimous vote from all affected owners. And since MacLeod specifically refused to sign it, he argued the rule change was dead on arrival. The new amendment also introduced a pretty severe restriction: 4 months. That was the absolute maximum amount of time per calendar year someone was now allowed to temporarily live in a hangar's guest quarters. The neighborhood basically took away guest houses with kitchens for these specific hangar tracts, replaced them with guest quarters without kitchens, and firmly capped the occupancy at just 4 months a year. This was the exact rule the HOA said MacLeod was breaking. Section 4. Living space and phone towers. Moving into the hearing itself, both sides had to prove their case. And they brought forward some incredibly specific and, frankly, highly unusual evidence. MacLeod went to wild lengths to prove he wasn't living there full-time. He actually brought his cell phone tower records to the hearing. By tracking his phone pings, He tried to prove mathematically that he was only at the hangar 30 to 35% of the time between late 2019 and mid-2020. And his alibi? He testified he had actually moved to a travel trailer located on agriculturally zoned land in Concho, Arizona, and claimed he'd only retreat to the hangar if there happened to be a forest fire near his trailer. You really can't make this stuff up. Meanwhile, the HOA didn't just say he was living there too much, they brought up a completely paradoxical angle. They alleged his living quarters only had 549 square feet. Now, why does that matter? Because to legally be considered a residence under their rules, a structure needs at least 1,200 square feet. So, they were essentially arguing he was illegally living in a space that wasn't legally big enough to be lived in. It's a fascinating bit of legal irony. Section 5. The judge's final verdict. After looking at all the intricate state laws, the voting math, and the incredibly unique evidence from both sides, Administrative Law Judge Kay Abramson had to deliver a final verdict. So here is exactly how she ruled on this complex web of claims. First up, MacLeod's petition to invalidate the amendment was entirely dismissed. The judge ruled the HOA's 75% math was legally sound. Next, the HOA's claim about MacLeod living there full-time, that was affirmed. The judge simply didn't buy the travel trailer alibi, noting his testimony was incredibly inconsistent. Interestingly, though, the HOA's square footage claim was dismissed because they just didn't provide enough proof. But ultimately, because the amendment stood and the residency violation was affirmed, the HOA emerged as the prevailing party. Section 6. The 2023 rehearing rejection. Now, you might think the 2020 verdict settled things once and for all. But an epilogue minute entry from 3 full years later shows this neighborhood dispute stubbornly dragged on. This quote from July 2023 perfectly captures the absolute bureaucratic finality of the process. After receiving multiple filings requesting a rehearing years after the initial decision, Judge Abramson had clearly had enough. She issued a firm minute entry explicitly stating those documents would not be considered, effectively telling both sides, stop filing, do not even respond to these. It was a decisive gavel strike letting everyone know the administrative battle was officially over. I want to leave you with a provocative thought to ponder for your own neighborhood agreements. How do we actually balance our individual property dreams with the legally binding reality of shared community rules? When you buy into a community, you're buying into a shared contract. This explainer shows just how complicated and, frankly, bizarre it can get when individual expectations clash with the collective vote of a neighborhood association. Thank you so much for joining me to unpack this fascinating case. And seriously, go read your community CCRs. See you next time.